has shown bias against their client on numerous occasions and should remove herself from the case. Court documents show Foss attorneys cite one example where Judge Lott denied the defense the opportunity to enforce a subpoena for a defense witness at a November hearing.
From the documents that I read, it does seem like there are numerous grounds that the defense is concerned about, times when the judge has ruled directly contrary to law.
That's Kay Levine, who is a professor at Emory Law School. She thinks prosecutors should join in on the recusal to avoid delaying results for the victim's family.
Joining in the recusal request would increase the chance that the judge would actually take herself off the case, and that means the parties would get a new judge. We would be starting from scratch. The case would go to trial with a new judge, free from whatever influence of the judge who recused herself. That eliminates then a potential ground for appeal.
And that hearing is set for tomorrow morning. Fox 5 will be there and will update you both on air and online. It's unclear if the trial will start as planned on February 2nd. At the live desk, Annie Mapp, Fox 5 News.
All right, we'll be today in the case against Colin Gray. He is the father of the Appalachia high school shooting suspect. After a full first day of questioning, attorneys are narrowing the jury pool, zeroing in on bias, prior knowledge, and who can separate emotion from the law. So let's look at what we should be watching out for with Lindsay Barron, a partner with the law firm Barron Ward and visiting assistant professor of practice at the Emory University School of Law. Welcome, Lindsay. So tell us, why is jury selection especially critical in a case like this?
Well, the Constitution guarantees every criminal defendant a right to a trial by a jury of their peers, and that jury be unbiased and be able to listen to the facts, enter with the presumption of innocence, and then fairly decide whether the facts show that the person has actually committed the crime. And if a jury member comes in with bias, or they're in some way biased during the trial, it can affect whether we have faith that the verdict they render was truly fair.
So let's lay out the ideal jury for the prosecution and for the defense here. Who are we looking for?
I think the prosecution is probably going to be looking for parents of children in school right now. People who are living under the constant fear that this is going to happen in their school, in their schools, their children's school. And they are familiar with the drills that their kids have to go through. And so that is going to be the kind of emotion that the prosecution is going to play on. The defense, I imagine, may want some parents too, but parents who have a different view of what parenting should involve. Parents who believe that there are risks in society and that the job of a parent is to train their children how to take those risks responsibly and how to, live in a world that is constantly full of opportunities to make bad choices, but to make the right choices.
You touched on a little bit about the bias here. So we know that this jury is coming out of Hall County, and then they're going to be brought back into Barrow County for the trial. Why does where a jury comes from matter so much in a case like this?
Well, in this case, the shooting happened at the public high school, one of the public high schools there in Barrow County. And so there are going to be a lot of members of the jury pool in Barrow County who, even if they're not personally affected, they don't have a loved one who was harmed, they are almost certainly going to have ties to people who were in that school, neighbors, church members, co-workers. And so if you take jury members from a different county, you don't eliminate that risk, but it certainly reduces it.
So why not just move the entire trial to another county? Why they decide to do the shuffle here instead of moving it all together?
That's a good question. That is often what happens. If you believe that even the judge could not be fair and impartial, you can move an entire trial. The solution they've picked here is an unusual one. You don't see a lot of cases where it's the jurors who come in rather than the lawyers, the judges, moving everything to a different venue. So this is very unusual.
All right, so last question here. This case asks jurors to judge a parent's decisions, not the shooter's actions. Why is that such a difficult line for the jurors to hold?
The idea is that at least up until a certain age, parents are responsible for the acts of their children. If parents can see that there's a real risk there and they don't do anything to protect against that risk. And I think what the prosecutors are trying to do is put the responsibility back on parents, that if you know that there's a risk that your child has mental issues, has said things about shooting people at a school, and you provide that child with an assault rifle, that you bear some responsibility for the choices that they later make.
All right, Lindsey Barron, thank you so much for laying it out for us. I only know of one other case like this, and it was out of Michigan where the parents were prosecuted. So we are definitely in some new territory.
Tonight, we are now less than 24 hours away from seeing the document that could explain why the FBI searched the Fulton County election hub. A judge has ordered the government to unseal the affidavit behind that warrant by tomorrow. Zach Merchant joining us now from our newsroom with more on what this all means here, Zach.
Yeah, this is all a pretty fast-moving story. Here's the latest. A federal judge in the Northern District of Georgia handed down an order, this order, over the weekend, unsealing the docket and giving the government until tomorrow, that Tuesday deadline, to file the affidavit submitted in support of the search warrant. So how does this all work? Prosecutors use those affidavits to make their case to judges that probable cause exists to support a search warrant like the one carried out by the FBI on the Fulton County election facility. Once the affidavit in this case is unsealed, we might start to get a better sense of the government's theory of their case. Now, in unsealing the docket, other motions in the case also became public, and one of them, Fulton County Commission Chairman Rob Pitts and the Fulton Board of Registration and Elections asked the court to force the government to give back the election materials seized in the raid, arguing that the search warrant was unlawful. Emory Law School professor and dean John Acevedo said it's going to take time for the case to make its way through the justice system.
This is a larger inquiry about systemic voter fraud at the county level. And, much like the RICO cases we saw with the Trump administration, this is likely to take several months to sort out.
And just in the last few hours, Fulton County Commissioner Marvin Arrington Jr. released a statement on the unsealing of the case, saying in part, quote, "This is a major win for transparency, accountability, and the people of Fulton County. I have said from the beginning, justice delayed is justice denied. And the public deserves to know what evidence, what claims, and what legal theory the federal government used to justify this extraordinary, sweeping seizure of our election records." Now, the U.S. Attorney's Office for the Northern District of Georgia, they declined to comment on the newly released Fulton motion today. Requests for comment to the Department of Justice and the U.S. Attorney's Office for the Eastern District of Missouri, which is reportedly involved in the case, they were not answered.
Yeah, still a lot of questions, so hopefully we'll start to get some of those answered with this new
story related to and focused on our environment. On Thursday, last week, on Thursday, the Trump administration rolled back the scientific finding that had been one of the foundational elements of the government's climate change regulations for the past decade plus. So I want to read you this. This is from the Associated Press. The rule in question, it was finalized by the Environmental Protection Agency. That rule rescinds a 2009 government declaration known as the endangerment finding that determined that carbon dioxide and other greenhouse gases threaten public health and welfare. It was an Obama-era finding, and that Obama-era finding is the legal underpinning of nearly all climate regulations under the Clean Air Act for motor vehicles, power plants, and other pollution sources. President Trump called the move, quote, the single largest deregulatory action in American history by far. EPA Administrator Lee Zeldin called the finding, quote, the holy grail of federal regulatory overreach. That finding, again, has now been revoked. We're going to bring in Emory Law Professor Mindy Goldstein now, who is joining us live. Professor, we appreciate you making the time. For those who maybe haven't had the chance to talk to you before, let's start with this. Can you share a little bit about your background in the environmental law space?
Sure, yeah, happy to, and thanks so much for having me. Like you said, I'm a professor here at Emory Law School. I've been on Emory's environmental faculty for 18 years now, and I direct our environmental and natural resources law program. So I've had a long time thinking about and teaching environmental law. I'm sorry, I can't hear you right now.
Let me try again here, Professor. I hope you can hear me now. But this finding revoked last week. What kind of impact could this move have?
Yeah, that's what we're all trying to figure out right now, but it could be quite impactful if it is upheld. So as you mentioned, the endangerment finding is the finding that EPA issued that allowed it to regulate greenhouse gas emissions from cars and trucks and buses, but also from power plants and oil and gas facilities. And essentially, the finding said that greenhouse gases are air pollutants under the definition of the Clean Air Act, and that emission of these pollutants endangers public health and welfare. In the recent regulatory rollback that you just talked about, this EPA said we got it wrong. In fact, the Clean Air Act does not allow us to regulate greenhouse gases. And even if it did, regulating them from mobile sources, from cars and trucks and buses in the transportation sector, just doesn't make sense. So we're going to decline to do that. We can expect in the coming weeks for them to roll back other greenhouse gas regulations that were also tied to the endangerment finding. So yeah, if it's upheld in court, this could be huge and could really hamstring the federal government's ability to regulate climate change.
And Professor, you alluded to this, but I want to ask it to you straight up here. There have been legal challenges already mounted to this EPA revocation of the endangerment finding?
Yeah, so this is far from the final step in this process. You can expect quite a lot of litigation around this decision. You will find environmental groups, a bunch of states, even a bunch of industries filing suit and challenging this decision. There'll be challenges based on the law that the EPA maybe mischaracterized what the Clean Air Act provided, and also based on its conclusion that the transportation sector, which is the largest emitter of greenhouse gases in the United States, actually isn't significant enough to warrant regulation. Those challenges will take a couple years to play out in court. They will first find their way to the DC Circuit Court of Appeals, and then this administration is betting on the Supreme Court taking it up.
Professor, one thing I suspect a lot of people may be wondering is, as they hear you rightly lay out that it's going to be a journey through the litigation process here and the appellate process, likely, what happens in the immediate term? Folks saw that the administration has rolled back this endangerment finding. You have shared with us that there are legal challenges to that finding and to the revocation of it. In the interim, does the finding stay in place pending an appellate court's ruling, or in the interim, is the finding jettisoned until an appellate court reinstates it?
Yeah, that'll be the first decision in the first court challenge. So as of now, the regulations are repealed. The transportation sector is not required to adhere to the existing greenhouse gas limits. However, we can expect court challenges very quickly that asks the court to stay that repeal, to hit pause, leave the status quo for now, and wait for it to work its way through the courts. So we'll have to see what happens on that front. In the interim, the regulated industry is trying to decide also what to do next. Do they go ahead and make changes to their operations, or do they wait to see how this plays out in courts? And then the final group that's trying to figure it out are states. Or at least for the last 15 plus years, when the federal government was regulating greenhouse gas emissions, states weren't allowed to step in. The federal government occupied that space. If the federal government is now stepping out, states have to decide if there's a role for them to step in and issue their own kind of patchwork of climate change regulations. So all of that is to be seen.
Last question for you here, Professor, and understanding that there are a lot of different elements and legal questions to wrangle with here, but you point out the role of states. If, and this is projecting a little bit down line here, but if it ends up being the case where states have more of the onus, if they so choose, to try to regulate some of these environmental issues, what kind of environment could that lead to? I would imagine different states would take very different approaches to their regulatory frameworks. And how would businesses that likely operate in a number of different states adapt to that patchwork of regulatory frameworks?
Right. I think it's going to be quite tough. And in fact, what you saw was a lot of the regulated industry filing comments on when this rule was proposed and saying, please don't do this to us. We're going to have a really hard time figuring out what it means to operate in all these different states if all of a sudden the rules of the game change so drastically. In addition, for our industries that operate not just in the U.S. but abroad, I think there's going to be a compounding complexity. So, for instance, abroad, especially in the European and Asian markets, there's quite stringent greenhouse gas emission controls when it comes to the automobile industry. So now when we have businesses here in the U.S., automotive businesses, if they are trying to sell to foreign markets, they're also going to have to make some calculations and decide kind of where and how to adapt their practices. So again, this is going to have a huge impact on everyday Americans, but also on all the businesses that operate and were regulated by this regulation.
And unfortunately, Professor, we are out of time, but it sounds like there's still a long road to go, particularly inside some of the nation's courthouses, to determine what the final outcome of this endangerment finding will be. Professor Mindy Goldstein from Emory Law School, thank you so much for your time and your insight. We appreciate it.
11 a.m. It took the jury less than 2 hours to come back with a conviction, and by the time it was all said and done, Colin Gray was led out of the courtroom in handcuffs, found guilty on 27 counts, including second-degree murder and involuntary manslaughter. Colin Gray, the father of the accused Appalachia high school shooter, Colt Gray. This is a first-of-its-kind trial here in Georgia of a parent of an accused school shooter. 2 students were shot and killed that day, as were 2 teachers. And again, Colin Gray found guilty on all 27 counts. His son yet to face trial, and Colin Gray will be facing sentencing here coming up at a later date. Let's talk more now about this historic conviction in the Gray case and the big legal question of what comes next. Joining us now is John Acevedo with Emory University School of Law to break down where things go from here. Good morning, sir. Thank you for your time.
Thank you so much for having me.
Well, you're welcome. What do you make of this historic conviction yesterday?
I was amazed at how fast the jury came to a decision of guilty within, an hour and a half, roughly. I think that shows, 2 things. One, that kind of jurors are fed up with these school shootings, and 2, the district attorney's case was much stronger than I think a lot of us initially thought.
So if you're the defense, what are the immediate next steps? I mean, are there pretty much wide open doors for appeals here?
So you have to go back through the record and see what appeals there are to be had. Everything from did the district attorney prove their case, to any motions to suppress evidence or objections to testimony. And they'll go through that to see which ones are likely to succeed and select those to move forward. At the same time, they're probably lining up character witnesses for that sentencing hearing coming up, as well as possible mitigating factors to see what, lower that sentence as their goal at this point.
Any reason why they wouldn't have brought those character witnesses out in the trial? I mean, when it was time for the defense to present its case, they just put the defendant on the stand.
One reason might be that they didn't have anything to say on the relationship between the father and the son, but they could talk about him in general. So they may not have been relevant to the question of guilt or innocence, but now they might be relevant to the subject of mitigation of the sentence.
What are the chances that this case on appeal could make it to the Georgia Supreme Court?
It is definitely possible. It's a new case. It's a novel theory of liability. And if you think about it this way, we hold people responsible for indirect killings all the time, reckless murder, depraved heart murder. There's quite a lot of these that we have, negligent homicide even. What makes this case unusual is that the father didn't know what the son was doing, so really wasn't a co-conspirator and was instead found guilty of kind of disregard for human life. So I would not be surprised to see this work its way up through the system, if for no other reason than it is one of the early cases on this theory.
And so if I'm hearing you correctly, it's that second-degree murder charge that could have some question marks around it, less so than the involuntary manslaughter?
Definitely. The involuntary manslaughter is much firmer ground for the DA's office, whereas that second-degree murder, it requires a higher level of culpability. The way to think about it is the lower the charge of murder, the less we think the person is responsible for the crime. Whereas if you're at second-degree murder, that really is disregard for human life.
Well, let me ask you this. Do you think there's any pathway for this case reaching the U.S. Supreme Court?
That seems highly unlikely. The U.S. Supreme Court has tended to defer to the states for criminal conviction. There is always a chance for a writ of habeas corpus or even a direct appeal. It is very likely those will be filed. It's very unlikely the Supreme Court would grant a hearing on those cases.
Okay, so how long could the appeals process take here? If they go through the Court of Appeals here in Georgia, I mean, we got 10 days worth of testimony, more than 60 witnesses. That's a lot of things to review, right?
It's quite a bit. They will probably have already started doing that. Typically, there's a 30 days to file the appeal. Of course, the court can take longer to hear it. So probably within a year, I would imagine you would have a final decision, whether or not it's going all the way to the Georgia Supreme Court. That won't delay the sentencing. The trial court will continue on with its processes as normal as this appeal is gathered and filed.
Look, unfortunately, we have reported on school shootings before. We, in fact, had a Sandy Hook survivor on our show in the last hour talking about her experience. And here we are 14 years later talking about Appalachia. It's likely to happen again, sadly, in our country. How do you think district attorneys nationwide looked at yesterday's conviction? Do you think they're now starting to get ideas of how they might handle it in their own cities should it ever happen there?
I think they are. And more importantly, I think it makes it less fearful for them. So if you're a district attorney, you don't want to be seen as wasting money on a case or, not pursuing the easier cases to lower crime. But now that this has been done, it's much easier for them to kind of be on solid footing to try it in their own home counties. And if the voters object, they can point now to a precedent where someone was convicted.
It's interesting. They had the Michigan case, but that was, I believe, involuntary manslaughter, and the parents went away for 10 years. Here you're looking at a gentleman who could very well go to prison for the rest of his life. John Acevedo from Emory, any final thoughts from you today?
It'll be interesting to see the sentencing, if the judge gives the maximum penalty or the minimum. I think that's something that will also guide how district attorneys behave. If the judge goes for the bare minimum, that might be a judicial sign that they're dubious about this. If they go for medium to maximum, then it seems like the judge themselves also felt the case was on solid ground.
Okay. John Acevedo from Emory University School of Law, sir. We appreciate your time as always. Thank you.
Steps to renew diplomatic ties potentially between the countries. The legal case against ousted Venezuelan President Nicolas Maduro is moving forward. Maduro faces charges of narco-terrorism, conspiracy, and possession of machine guns, among other charges. With me now is Lori Blank. She is the director of the International Humanitarian Law Clinic at Emory University, where she's also a clinical professor of law. Welcome to you.
Thanks for having me.
So what will be critical in how the U.S. proves its case against Maduro and his wife?
So there's a couple of different questions here. In terms of the crimes that they're being charged with, on some level, this is really a, criminal case. The prosecutors in the Southern District of New York are very experienced in cases of this type. The challenge here is whether or not the case can go forward at all, whether or not former President Maduro has what's known as head of state immunity, which would mean that he cannot be prosecuted, he cannot be brought into a U.S. court at all. And that's, of course, what his lawyers are going to argue. They hinted to that in that first appearance when he stated that he's the president of Venezuela. And international law protects heads of state and heads of government from this type of any kind of prosecution or civil cases in order to enable all leaders to do their job, to engage in diplomatic relations with other countries, to be able to travel and not face the threat of arrest or harassment, regardless of whether they have engaged in bad acts or not. It's really key to stability in the international system. So we'll see whether they succeed in that regard.
Yeah, and it's clear that Maduro and his defense team want to make that front and center. He tried to bring that up with the judge. The judge said there'll be another opportunity for you to kind of make the case on that. But there is some precedence, right? Going back to the case of Manuel Noriega, a Panamanian leader who was captured by the U.S., who was ultimately, tried. He was declared, a prisoner of war by a federal judge. So do you see real parallels here on these cases?
Well, there are a lot of similarities, but one important difference here that ultimately the court is going to have to dive into is that Noriega was not actually the head of state. He was the head of the military. He was not the head of state at the time. And Panama did not make any requests for immunity for him. So the country of Panama, the government of Panama did not view him in that regard when he was facing prosecution. We have a different situation here. We have questions about whether Maduro was a legitimate head of state, because we know there's a lot of evidence that he obviously failed to concede at least one, if not two, elections. The U.S. did not recognize him as the president after that. And a court is going to have to examine whether that question of legitimacy undermines and, it gets rid of his argument about being head of state. So it's a bit different from Noriega.
But then quickly, I wonder, will that be a problem, for the U.S. in its case, because the U.S. is okay with his vice president being sworn in, as acting president, and if the argument is that he is illegitimate, then why is the same argument not being made for the vice president? And will prosecutors, be held to that?
I think this is a big hurdle for the prosecution in this regard. We also have different statements immediately after the operation last week, referring to him as the leader of Venezuela after he was taken into custody. And of course, the current interim president, Rodriguez of Venezuela, has said that he is still the legitimate president. So the government of Venezuela appears to view him that way. Courts tend to defer to the executive branch here with regard to head of state immunity questions, because the president and the executive branch generally have the authority to recognize governments, to recognize other states. But this one is particularly complicated, and I think it's going to be a real issue for the courts.
All right, Lori Blank, thank you so much of Emory University. We'll have you back because this really is just the beginning, isn't it? Thanks so much.
We're seeing a lot of different feelings towards the president's actions in Venezuela. While in one local rally, protesters called his actions illegal, in another, people thanked him for arresting who they describe as a dictator.
¡Que viva Venezuela!
Dozens of Venezuelans living in Atlanta say they want President Donald Trump to know they appreciate him.
Today we gather to show support to the President Donald Trump, to the precision of what he did, and the help that he's doing to us.
Gloria Merhedge is originally from Venezuela but has lived in the U.S. for 25 years. She says her phone started going off when the U.S. began bombing the country early Saturday, but she and her family weren't mad about it.
We knew that something good was going to happen, and it was good. It was very good.
She joined other Venezuelans who celebrated along the Atlanta Beltline Sunday. Meanwhile, in Midtown, groups who call the operation illegal held a protest.
We are a nation of laws. This should have been congressionally authorized before going to war with a foreign country.
President Trump has said Maduro's arrest was necessary to protect America's security and economic interests. He also described Maduro as a criminal leader instead of a head of state. Lori Blank is a professor at Emory University and an expert on the legal rules of war. She says the attacks on Venezuela violate the United Nations Charter.
One country cannot use force against another country. That is a basic rule in the United Nations Charter. The U.S., Venezuela are both members of the UN, both bound by that treaty. There are 2 exceptions to that prohibition, but neither of those applies here.
According to Blank, the exceptions would be if the UN Security Council had authorized a use of force, or if the U.S. was acting in self-defense if Venezuela had attacked the U.S. first. Reporting in Midtown, Annie Mapp, Fox 5 News.
Welcome back. We're diving deeper into what the guilty verdict for the Appalachia high school shooter's father means and the possible precedent it sets.
Yeah, for that, we turn to Emory Law Professor John Acevedo. He joins us live this morning. John, we appreciate your time. And I want to start with this. I just want to get your thoughts in general, kind of an overview. What are your takeaways from this trial, how it played out, the length of time, just generally, what are your thoughts?
I think my general thought is I was surprised at how quickly the jury convicted with a less than 2-hour deliberation. It seems like they were quite convinced by the prosecutor's case. And I think that bodes for this same precedent to be used in other states. If it was that quick to get a conviction here, I think DAs around the country will be less worried about trying such a case.
We're curious as to what this could mean nationwide, because it's a first of its kind case, right? So what do you think this means for a potential precedent moving forward?
It's very likely this will set precedent. And, you know, the precedent is technically only binding in Georgia, but it really shows DAs around the country that this is a possibility and a way to deter school shootings. And there have been very few things that have deterred school shootings, so this may be something that is very quickly turned to by other district attorneys around the nation.
We've been taught since we were children that in the American justice system, you're innocent until you're proven guilty. The trial for Colin Gray has not taken place yet. He has not been proven guilty, although, you know, people are pretty sure that we know what happened there. Why did the trial for his father take place first, and how can he be convicted when of murder when the perpetrator has not been convicted yet?
So there's a few reasons the district attorney may have gone first with the father's trial. One might be because it was a more speculative trial. They wanted to try it quicker, whereas you point out the son's, innocent until proven guilty, but the evidence is fairly overwhelming against him. So it may have been the district attorney's choice to put the more difficult case up front. It also kept the son off the stand. He couldn't really be called by either side. He would have pled his Fifth Amendment right against self-incrimination. Sure. And you can imagine the DA not wanting the son to stand up and say, no, I did it, my father had no idea.
Mm-hmm. Well, let's talk more about the accused Appalachia high school shooter, Colin Gray. We know that his trial is still in limbo as it pens a mental evaluation. So at what point could we expect to see him in court officially?
My guess would be in the next 3 to 6 months. Mental evaluations do take time. They have to be written up, but it's likely that could be finished in a few weeks. And then it would be a matter of setting a date. It'd also be interesting to see if he is found mentally competent, if there's just simply a plea bargain at that point to avoid the trial.
If I could just follow up really quickly, what is it about this evaluation that makes it last so long? I remember we were first questioning in November when we could see Colin Gray in court. So what does that process look like for someone who isn't familiar?
So it really is finding a forensic psychologist. So you just cannot grab any psychologist, in the phone book, which means there's a limited number of folks. They have additional training and expertise in this area. Usually courts like to use someone who has been involved with courts before. So there's a finite number of people. So some of the delay is simply caused by scheduling, that you have to find an open slot. Other, businesses and folks want to use them as well. So it isn't like they're just sitting there waiting for this case. The other thing that may be going on is the cooperativeness of the defendant. We don't know if he's been cooperative in these evaluations, if he's sitting mute. There's many ways a defendant could sabotage a psych eval and therefore cause delay.
Yeah. So much still to unpack from this. Emory Law Professor John Acevedo, we really appreciate your time and your expertise this morning.
Absolutely. Thank you.
Operations in Iran. As Congress prepares to vote on those war powers resolutions, Emory University international law professor Lori Blank says questions remain over whether this action was constitutional.
I think one of the big issues in this current situation is the president's unilateral actions in launching, U.S. military operations, whether that is constitutionally appropriate.
But she says now the conflict has started, there's very little that Congress can do to pump the brakes. 70 degrees here in Midtown Atlanta, partly cloudy.
The director of the Juvenile Defender Clinic at Emory University weighs in on a congressional survey looking into children with special needs being locked up.
A bipartisan report finds nationwide criminal institutions are being used to incarcerate kids with no charges or minor charges due to those individuals needing mental health care. Emory Law Professor Randy Waldman says it's a repeated cycle.
They get released in the hope that they will receive mental health treatment. That treatment doesn't arrive, and they get arrested because the problem persists, because we haven't solved the problem yet.
She hopes this report can bring awareness and that court systems can stop putting kids behind bars based on mental health conditions. Mary Ryan Howarth, 95.5 WSB.
I'm Orlando Montoya, and this is Georgia Today. Georgians are reacting to the U.S. Supreme Court's decision striking down many of President Trump's tariffs. The 6-3 decision handed down today is a major blow to the president's signature economic agenda. Democratic U.S. Senator Raphael Warnock welcomed the ruling, calling the tariffs reckless and a way for the administration to, quote, move wealth from the bottom to the top. Emory University law professor Alexander Volek said it also reins in the presidency's increasing power.
It's the Supreme Court that has been in part responsible for allowing the imperial presidency to develop. And so I think that if they're cutting back on that, maybe they realize that it's a problem because of Trump, but it's actually been a problem for a long time. And so I think it's a welcome development even apart from Trump.